really is a job.
Hello everyone.
Yeah, so I'd love to show you some stuff with time.
My name is Maciej Bernatt. I am a law professor at the University of Warsaw, Poland. In terms of disclosure, I can say that my research is basically funded by Polish research, public money, Polish National Science Center. And I did some fellowships, like Fulbright fellowship. So this would be my disclosure. No conflict of interest. Um, so we have a great panel. We will discuss the interrelation between free speech and antitrust. What I would like to underline at the beginning is that, at least for me, coming from Central and Eastern Europe, that experienced in recent years democratic backsliding, I am kind of surprised, I must say, to see similar patterns going on in the US. So I was so the question in this context I think we can be asking is the place of antitrust. So how antitrust is interacting in within this new political and economic context. And I think looking at free speech is particularly relevant to consider first the role of antitrust, potential risks of antitrust becoming a tool in the hands of governments and powerful private actors, for example, to chill criticism, or maybe the risks that antitrust will become meaningless. So during this panel, we will focus basically on two questions. The first one being use of market power to censor free speech. So this will be sort of a follow-up of what yesterday FTC Chairman Andrew Ferguson was talking about. We'll be asking a question: what can we do, or maybe what we should do under antitrust to address the risk of censorship. And the second question will be the use of antitrust civil lawsuits to silence criticism. So we have with us Greg Day from University of Georgia. We have Eleanor from New York University, and Matt Stoller, a research director at the American Economic Liberties project. So I would like to give floor first to Greg. Please, Greg will give us an overview and panorama where we are in terms of the relation between antitrust and
Thank you very
free
much.
speech.
Thank you very much. So I'm Greg Day, and in terms of disclosures, I'm most exclusively paid by the University of Georgia. I guess in the past 3 years, if there's nothing really else, I've received a little bit of money to write an article for the LP Society, and also is on the board of directors of a homeless ministry, which I don't think has much relationship to anything that we're doing today. So I wanted to start off by talking about it's really important, this burgeoning relationship between free speech and antitrust and the First Amendment, especially with the rise of things like digital platforms and increasing market concentration. The ability to speak and share ideas and transmit information is becoming an increasingly important topic. One thing I guess I want to talk more about today is I actually find it very interesting. So in antitrust, there's been a long-standing and sort of rich relationship between antitrust and the First Amendment that's oftentimes gone unnoticed. Oftentimes because a lot of the precedents and the overarching principles that have been occurred more in the lower courts than in the Supreme Court. And a couple sort of overarching principles have emerged that have guided both First Amendment and antitrust courts almost kind of hand in hand. Probably the most well-known is the Norr-Pennington Doctrine, but that's, as we know, many of us know, that's less about freedom of speech, and it's more about the right to petition government. So, but that's been the biggest association between the two. But the actual transmission of ideas and thoughts has also become relied on older precedents between the two. One of the bigger ones is recently Amazon and Apple have been sued for suppressing information. Federal enforcers have sued them and said that the suppression of information on their platforms prevents information from getting to consumers, and consumers can't comparison shop, and this will harm them from finding the lowest price for the highest quality goods. Part what's sort of interesting about that is that precedent came from a Supreme Court case in, I believe it was the late 70s, but that was directly resulted from the commercial speech doctrine that was set, where the idea that the most amount of commercial information will help inform consumers. For that reason, should be protected in the First Amendment. It was just only, I think, within months or a year after that case did the Supreme Court adopt that same logic into National Society of Professional Engineers. In addition, but what's even more sort of fascinating to me is not just in terms of maximizing information, but that's the general principle that has come out of it. But there's actually been a couple cases based on misinformation. There's been a few cases where plaintiffs have alleged that defendants have smeared them using lies or misinformation, and because of that, it's driven consumers away from them, and that should be considered an anti-competitive behavior. Using kind of like the same logic of maximizing information that was used in the previous cases, antitrust courts have taken this position of saying that misinformation and lies aren't anti-competitive. In fact, that is a form of competition. One judge stated when dismissing this type of claim said that he's endorsing traditional free speech principles about self-correcting markets, but here, self-correcting markets of ideas, saying that the genuine anti-competitive effects of false and misleading statements about a competitor are minimal at best. And using precedent, if such statements should be false or misleading or incomplete or just plain mistaken, the remedy is not antitrust litigation, but more speech, the marketplace of ideas. Other courts have expressly said that, have used the term that it sets the stage for competition. Other cases are sort of similar. There's been a couple cases where plaintiffs have actually sued and said that their exclusion harmed the marketplace of ideas, and this should be considered an anti-competitive act. One was Gary Johnson when he ran for president. He was excluded from the presidential debates, and he sued the Presidential Debate Commission in an antitrust case and said this harmed the marketplace of ideas. And the court said, well, ideas just aren't an economic market. This is too insufficiently economic, and it doesn't apply. There's also been boycott cases. The National Organization of Women has been involved in a couple cases where they sued and were sued for economic boycotts. And even though it was an economic boycott, the court said that was primarily a social or sort of an expressive boycott, and it wasn't primarily about gaining an economic advantage. So even though that heavily involved speech, it didn't raise antitrust concerns traditionally. And even First Amendment cases have mentioned antitrust principles. There was a case out of Miami with the Miami Herald where they sued because they were being required to report multiple sides of a story, and they said that was a First Amendment violation. The Supreme Court agreed and said that was a Supreme Court violation, even though when the Supreme Court ruled the First Amendment interest in the public of being informed is in peril because of the marketplace of ideas today is a monopoly. So because the Supreme Court even mentioned that the First Amendment needs to take precedent over antitrust litigation. So a lot of this, but one thing that I found is particularly interesting is antitrust hasn't gotten involved in asking questions like about quality or whether markets, and this is sort of, to me, what I find interesting about this panel, and this sort of the next step is asking, does antitrust need to revisit some of these precedents about the ideas that antitrust shouldn't get involved in gauging the quality of ideas or accuracy or truthfulness of ideas?
Okay, thank you very much. So, Eleanor, over to you, please.
Thank you. I do have slides, but I don't think I have time. I'll just leave the title up. When we were asked to talk on the subject of First Amendment rights and antitrust, of course, there's the huge category, most of which Clem was talking about, where there is a huge interrelationship and symbiosis. You have competitive markets, and competitive markets facilitate ideas. There is another concern I have, and I'm going to talk about today, which is it's sort of the other side of the coin. And is, as I will develop in a minute, the possibility that in this world nation today, we need collective political action and that antitrust might stand in the way, and that threats of antitrust suits might chill speech and political action. And that is the subject I'm going to talk about in my next couple of minutes. So we're in a world in which, well, I go to the next, let's see. I shut it off. That's okay. Okay. We're in a world, I'm going to talk principally about what I call the lawyer problem, just to put it into a concrete example. We're in a world where, okay, thank you. We're in a world where the government has brought actions of retribution against law firms, executive orders. I don't mean legal actions in court yet. The executive orders against law firms, the executive orders against universities for representing the, quote, wrong people that are not sympathetic to the president and teaching the wrong subjects and having the wrong policies like inclusiveness and are therefore in the target of being ruined by our government. And a question is whether collective action is necessary to push back the repressive government. And whether, if there is collective action, are there obstacles? We know there are obstacles. Is antitrust one of the obstacles? So I am thinking today about what space is necessary for collective action to push back on illegal government orders, and whether the antitrust laws are actually too narrow to give the space for important political action that is not action to get more market power, not at all. It's not the usual antitrust case, but the law firms, for example, are so frightened of losing their whole law firm that they will cave into the remedy. And is there a way that we could facilitate or at least remove the obstacles to collective action? So I did want to read a quote, which will take up too much of my time, but I do want to read it because it will tell you where I am at in thinking about this problem of, do we need more space in the antitrust law, more space to do collective political action in the antitrust law, and what is the balance between allowing collective political action and disallowing combinations that could be called conspiracies, boycotts against the antitrust laws. And this is the quote that you will probably be reading right now because it's on the screen. The first play in the autocratic playbook is not to attack. I'm sorry, my eyes are so bad. I think I'm sorry. I know what I need to do. If you'll excuse me 1 second, just go. My eyes are so bad, and I need light. Great. Okay. The first play in the autocratic playbook is not to attack everyone at once. Rather, it is to go after one law firm, one judge, one university, one journalist. This is from Ian Bassin. The strategy isn't just to silence the immediate target. It's to make others want to watch and learn, to convince them that resistance is dangerous, costly, and futile. The strategy works, and Ian Bassin talks about Hungary, Russia, etc. The autocrat can consolidate power, but the strategy fails when there is collective action to push it back, when we recognize it is a threat and we need to push it back. That is what is motivating me today. As an antitrust lawyer, thinking of the problem of Nor Pennington, as Greg has mentioned, Nor Pennington can be an exception from antitrust because petitioning government is an exception, a recognized exception. Political boycott is a recognized exception, but those exceptions are not broad. And so I want to give you a couple of hypotheticals. I want to just say a word about where the law is. And my final statement is really to say this might be a small piece of the picture on the balance between allowing more collective political action and applying antitrust law. So it's one piece, and it's one piece where we can all think about what else are the obstacles to peaceful, nonviolent, collective political action that we might like to move the law to allow that side to be more robust. So the examples I want to give you, and you will know some of them, for the law, 0 minutes. Oh my God. Oh, all right. For the law firms, can the lawyers sign a brief, the brief that Perkins Coie briefs are being filed today to support Perkins Coie, the law firm that the executive order says you have been dishonest and disgraceful. You have represented Hillary Clinton and in collaboration with George Soros. And therefore, here are orders against you. And of course, we know Perkins Coie is fighting. Hundreds of law firms are supporting, but hundreds are not. And some have caved. And the question is, what does it take to get the collective action of those who have caved? So number one, yes, they can file the brief. Let me go to my number three. What if there are two groups, the lawyers who sign the brief and the lawyers who say, I can't risk it to sign the brief because my whole law firm will disappear, but I don't want to stand in your way. I agree not to poach your lawyers. That is in difficult territory under antitrust, even though you could say it's in connection with petitioning, but it's probably outside of petitioning. It's just in this territory where I am saying, I think this is not a true antitrust problem. It is not a problem of the law firms who would agree to, no, I won't poach your firms to help you with your fight against the illegal order. And therefore, I think it's in this penumbra. I think we could work in the penumbra sorry, I didn't mean, I'm very sorry. I didn't know I was facing you all with my, sorry. Working in the penumbra because it is so important to leave the space and not have to worry about the threats of antitrust action if you do good, peaceful political pushback. Thank you.
So thank you so much for having me talk. This is a fascinating set of perspectives, and that's a really interesting point that you just made. I'll start with disclosures, which have sort of become a humble brag thing. So I work for a nonprofit, and we take money from foundations, which is fine because it's just monopolists who died a long time ago. Google had me fired from a think tank in 2017, and Facebook hired a political consulting firm to spread mean rumors about me. This was a while back. I'm the co-host of a podcast called Organized Money, and we interview business leaders in concentrated industries, and that's financed by readers and listeners. I'm too much of a perfectionist. I try too hard, and I care too much. Okay, so I'm going to walk through. Actually, I'm not, because I don't have. Oh, well. My iPad's not letting me. I'm going to walk through 4 examples, and I'll try my phone. Apparently, this is the panel where everyone plays with their phone. So I appreciate your precedent there. So I want to walk through 4 examples of censorship and concentration, and I'll mention a few things around antitrust. So I'm coming at this from, I'll put on my hat as a small business person who I operate a media outlet in an environment dominated by big tech, although with some areas that are not dominated by big tech. So here are 4 examples of speech and concentration. So first is the Hunter Biden laptop story. So the New York, we sort of know the details around this. The New York Post did a story using content from Hunter Biden's laptop, alleging corruption involving Ukraine and his father. The Biden campaign reacted angrily. A bunch of national security people said, this is clearly Russian disinformation. And then the FBI warned the platforms not to spread it. So the platforms blocked links. It turns out that the content of the laptop was authenticated, was real. Even if the full scope of the story, I think, is debatable, maybe not true, but certainly parts of it are true. But the censorship didn't work. And there were lots of right-wing outlets who, operating on what's left of the open web, talked about it. There were lots of emails about it, podcasts, and then Republican politicians went on the floor and said, this is outrageous. It was sort of a Streisand effect, where it actually became a big story. It wouldn't have been. And everyone backed down immediately. So this is the part of the censorship story. It matters, but it also didn't work. And there's a sort of natural immunity to censorship there. What most people don't know is there was a parallel story, almost an identical story, that happened in the waning days of 2024. So a foreign source, likely Iran, hacked the Trump campaign and found a media dossier that the campaign assembled on its various VP candidates. One of them is J.D. Vance, who they ultimately picked. And they were offering this dossier, which was all just public information, to a bunch of journalists. And most journalists said, no, I would never take hacked information. But there was one journalist who did, and it was a guy named Ken Klippenstein, who had been at a series of media outlets and left to start a Substack, which operates, financing through subscriptions over email, which is an open system. And, he said, yeah, I know it's from a foreign intelligence source, but it's still news and I'm going to publish it. And he did. Okay, so then the Trump campaign says this is outrageous and this is hacked foreign materials. And the FBI, the Trump campaign, and I guess the Biden administration worked together to tell foreign platforms that this is disinformation. So he writes about it on his website, because you can't block a website. That's fine. Then he links to it on Twitter, and he gets kicked off of Twitter. Now, he had been in fights with Elon Musk on Twitter years ago, so Elon Musk already didn't like him. But he gets suspended, permanently banned. And his links were also removed from Facebook. And Google, this is interesting, and I don't think I hadn't seen this before. They actually made it impossible to save the dossier itself on Google Drive. So you just couldn't save it. It's like this really crazy story. And then the FBI sends a young agent to visit Ken and say, hey, did you know that this is foreign disinformation? And he's like, yeah, I know it's foreign. You can go away now. Now Ken refused to back down. He had experience, he had potential pro bono legal support, and he had financing. But, if he didn't have all that, he wouldn't have been able to stand out. Now, the third example I'll go over quickly. It's a documentary, No Other Land, which was made by an Israeli and a Palestinian, wins an Oscar, can't get any distribution on a highly vertically integrated streaming apparatus. And when an independent movie theater in Miami Beach showed the film, the mayor tries to have the theater evicted from their venue. And the fourth example, I'm just going to point to it. There's a lot reporting on it. Chinese control of Hollywood. You don't see Chinese villains in movies, and there's a reason for that. It's the same sort of dynamic. So the point here is consolidated tech platforms and vertical integration in streaming foster top-down speech controls. And that one could say that's un-American because censorship is un-American, or one can say, as Richard John would say, that censorship nationwide controls are un-American. We should do it locally. At least that's 19th century. So the point is that it's new. This is new and weird. So an expansive Section 230 combined with antitrust action that takes 8 years or really long time to get any sort of remedy is really problematic. And I think the basic problem in our political and antitrust discourse is that we're asking how to censor is who is censoring instead of focusing on the point that a consolidated national media and communication ecosystem inherently leads to censorship. A person with a pen editing a magazine is an editor. A person editing an algorithm structuring 90% of what we search for is a censor, and that is inherent. Now, there are variety of legal tools you can use. I've seen Shaul Sussman wrote a fascinating article about how to use Section 5 of the FTC Act to address censorship, because you don't have to do all sorts of market definition garbage. There are potential cases around, about use of the Sherman Antitrust Act, Clayton Act, but fundamentally, and don't worry, I see you. Fundamentally, the question here is really, I think, to Luigi's point, there's a Sherlock Holmes aspect to it, right? The Sherlock Holmes problem, where the censorship is just going to happen unless you just cut down the size of these dominant platforms. And then you can see that the antidote to censorship is independent business and open systems. And I think those, you see this with the vertical integrated streaming. You don't have those, and so it's hard to get content into those institutions. And then with the Hunter Biden laptop story and the Ken Klippenstein story, you saw the opposite. You saw attempts at censorship that didn't work. And so you want to promote those kinds of institutions that are sort of the immune system to censorship and try to cut down the disease itself, which is consolidation. And of course, then there's politicians that want to censor. And that's just a question of who we vote for.
Okay, thank you. Okay, so I would like to come back to what Eleanor said and just ask you, Eleanor, a question about the safe harbor for such law firms that would like to think about such collective actions under current antitrust rules, when they will be safe.
Yes. So as to when they will be safe, I can't guarantee, but I'll tell you a way to think about a safe harbor for true political collective action. Perhaps adopting the framework from Citizens United. Political speech is protected. In certain cases, when political speech is at least front and center, for political speech to be illegal, and it can be collective action, it would have to be the case that the government has a major public interest and that the law that is interfering with political speech is proportionate to that major public interest. And so here, this involves whether the per se rule applies or not. Because in many of these cases, like the case hypothetical I gave you, if there's an agreement that we won't poach your firms, go ahead, we want to support you, Perkins Coie, but we won't poach your firms. That's really in what is often called a per se area or a near per se area, depending on circumstances, in antitrust. The per se rule is actually, it's been very important to U.S. antitrust in making a very strong signal and a strong law, but it's actually overbroad to make it a very strong right line rule. And the Supreme Court has been sympathetic in commercial cases to say, when we don't really think the market is harmed, when there might be some good aspects of this conduct, we will relax the per se rule. So that's my idea, that at least we should argue there, not to say we win, but we argue that this should be rule of reason. It shouldn't be per se. And under rule of reason, we see the purpose and the intent and the effect and let it go through.
Okay.
Can I take the other side of the? So I think it's important. Like what you're trying to say is there's a legitimate fear from a lot of lawyers that they'll lose their business if they take a stand, and you should try to kind of create disincentives to that. And part of me, I sympathize with that argument, but if you're going to create an exception here, you also have to create the will for these lawyers to avail themselves of this exception. And the problem isn't that they're afraid of coordinating, the costs of coordinating. The problem is that the people, the Sullivan and Cromwell types, Kamala Harris's husband, like they're just greedy. They want money. And so what'll happen is if you create an exception, it'll get widened. This is my fear. It'll get widened. And then like okay, so some nice lawyers who are like, we love, go America. We're going to sacrifice our money for integrity. They'll do it. But then what about the guys who are like, I'm, Scott Barshay of Paul Weiss. He's just like a mercenary and he's not going to sign that. So what's the problem we're actually solving? And then let me look at the silver lining of Trump trying to terrorize the lawyers. Like, I think we've been in this conference for long enough and talked about the lawlessness among these lawyers for long enough that I think it's pretty confident that Trump is just taking advantage of a totally lawless environment. And most of these lawyers should have been disbarred a long time ago. And the fact that we didn't disbar them, I mean, Ken Walker is shredding documents routinely at Google, and this guy is respected. And we're the only organization that files a bar complaint against him. 3 judges have said this guy needs to stop shredding documents when they're under a litigation hold. This is the problem. This is the thing that says laws are just suggestions. And then, of course, so this tin pot, guy comes in, starts ordering them around. And of course they knuckle under because they don't believe in the rule of law. They never believed in the rule of law. And that's the fundamental problem here.
Yes, so everything you say is correct. So why would I want to propose this anyway? It's almost symbolic that we should be thinking about the balance between facilitating, not standing in the way of, not having one more straw to stand in the way of collective political action. And I want people to think about other ways to remove other barriers. So everything you said was right.
No, and I think you're right that, a lot of lawyers are scared, and we do need to figure out a way to support lawyers who are scared and want to do the right. It is important to tilt the incentives, find a way to tilt the incentives as you're trying to do. And so I admire and appreciate what you're looking for. So I think that it's important. It's also important to reward the lawyers that actually did the right thing, because there are a bunch of them that did and that are. But I think it's a real problem that we have people at Paul Weiss who are, they have $7.5 million of profit, not just revenue, profit per partner. And Hakeem Jeffries was there for 6 years as an associate. Chuck Schumer's brother works there, Sonia Sotomayor, Ruth Bader Ginsburg, and Elena Kagan were all summer associates at Paul Weiss. This is a problem. This is a problem for our society. And I've heard a lot of kind of anti-Trump rhetoric here, and I didn't vote for Trump and I don't like Trump, but this is not, the lawlessness that we're seeing did not start with Trump. And if you are looking at this sort of liberal establishment, look in the mirror. This is a problem. And that the best thing that could come out of this is to say, you guys are no longer in the club. You can have your own weird little club, right? And I think that would be a meaningful silver lining. And so that tilts the incentives too. So we're all about tilting incentives together.
Right. And I do want to stress that these executive orders they're chilling speech, they're chilling representation, they're trying to make sure that nobody will ever bring a lawsuit against a president who threatens this retribution. So it's a huge freedom problem, and we need a pushback on all fronts. We're legitimate.
Sorry, a last thing. I apologize. I would like to see. So one of the things that Trump is doing is he's saying, if you offer pro bono services in response to my, bent the knee, one of the things you do with pro bono services is you're going to negotiate some of these trade agreements, which is so corrupt. To be oh, the reward for Paul Weiss is you get to negotiate a Japan trade agreement for your clients. I think that there should be a sustained effort to file bar complaints against the lawyers that are doing this. This is totally outrageous. It's completely lawless. And I'm not seeing anybody filing bar complaints, even though we know the bar is going to ignore it. Put some damn pressure on the legal institutions that ostensibly care for the rule of law. This is crazy.
Okay. So I would like to come back to what Greg said, and you mentioned that misinformation and lies are part of the competition, that this is something that is accepted. You also said in the context of free speech that the challenge we are facing is the question of how to assess quality. So I wonder what's your view on how antitrust should develop in the context of potential censorship. Yesterday we heard about the use of Section 5 Act as a theory of vertical foreclosure of content providers by platform. I read about potential use of Section 2, but it would in any case involve the need for assessment really of the content. So what are your views on that?
I mean, that's a fantastic question. And I thought, especially like some of the talk that we heard last night during dinner, I think got to a lot of that. I thought it was actually kind of fascinating, was for antitrust to try to improve or enhance the marketplace of ideas, it almost in a way requires government or antitrust courts or enforcers to assess, like, is this market accurate? Is this market truthful? Is this responsive to consumers? And that oftentimes can look eerily like content moderation from government. And I thought it was interesting. So there is a lot of antitrust lawsuits that respond to the information of the expression markets. But antitrust has really tried to stay away from saying, is this market full of misinformation? Is this market full of good expressions? Instead, it just tries to maximize, it goes through the commercial speech doctrines, like just tries to maximize information. For instance, like the Live Nation lawsuit that involved the was a Ticketmaster, and it does talk about quality, but it talks about quality in the terms of the platform that you're using. Is the platform where you buy tickets and such, is this good? But it really tries to stay away from asking questions like, are we getting good? Are we receiving good, high quality performances? Instead, it just looks at output. Are we receiving sort of enough performances? Or the Penguin merger also really tried to stay away from asking questions like, are books good? Would this harm books? It talked about authors' compensation, which you could make a stretch on, but the lawsuit kind of avoided asking that question, because a lot of the question we are asking about when it comes to like X's moderation and the lawsuit against X's, you're having to ask, like, do consumers want a market with full of information and a lot of it's bogus, or do we want a market that companies sort of exercise the First Amendment right to exclude speech? And I think largely antitrust has tried to just stay out of those debates. It just goes in this idea of we want to maximize information, we want to maximize expression. But it seems troubling to have government step into this role of saying, how is the quality of expression?
So let me sort of push back a little bit. Now, I want to hear your sort of, I was at the Penguin trial and I watched Stephen King testify, and I saw, I mean, a lot of the testimony, you're right, a lot of it was about author revenues, but Stephen King was talking about the quality of books and about the diversity of books and about how when there was consolidation, like he used to write Westerns and he couldn't anymore, it was harder. And I know Merrick Garland talked about diversity of views at the press conferences, and there was a lot of discussion about the diversity of books. So how do you square that with your sort of with the argument that that antitrust doesn't look to those questions?
No, I think it's a really good point. Oh, sorry.
Sort of to Greg, I didn't think you were arguing that quality was not a part of the antitrust enterprise, and the competition tends to produce some people who will attract customers by greater quality.
Oh, yeah.
Really.
No, I'm saying absolutely that is definitely part of the market. And to a lot of the market participants, that is a really big, like to Stephen King, that's a really big part of it. I was just saying more, in a lot of times when courts level the rulings, or when enforcers, draft the complaints, they really try to avoid going into those waters. But certainly when you have like testimony, those things are very important to the people that are involved in the market. It was just a lot of the times the complaints and the rulings try to shift away from that. They seemed a little kind of shaky to jump into those markets. No, but I definitely agree. It is very important.
And misinformation, I agree with you, Greg. It's not a traditional part of trying to protect good quality of information in antitrust. Competition can produce misinformation, and it might be the case that there's an unfair competition problem when somebody is competing on the ground of misinformation, but not usually an antitrust problem.
Yeah. Oh, I just add. So I thought one thing where it sort of hints around it is they do talk about output a lot, and so output restrictions do restrict the diversity of books and things like that. So I think generally they try to just frame it in like generalized terms like output, but I think they just try to avoid saying, is this market, because it's kind of a hard thing to prove, like, is this market actually of expression, like of a high quality as we'd like?
So this is something that Shaul talked about in his paper, is that the use of Section 5, and this is theoretical, but the use of Section 5 allows you to escape some of the narrow jargon and market definition problems, which I think antitrust enforcers have to adhere to. And if you can do that, then you can potentially do things like I know Dave Dan was talking about this, how when Twitter just stopped allowing links, it degraded the product, or you could argue it degraded the product, but it certainly was a harm to rivals. At a certain point, they just tried to stop all links to Substack, which was Substack was very upset. I mean, it was clear that they were trying to injure a rival because Substack started something that was Twitter-ish. I think you could argue with something like the Ken Klippenstein example or the Hunter Biden laptop example, and it gets weird because there's national security elements, but you could definitely argue that's a degradation of quality. And if you don't have to deal with market definition issues and you can use Section 5 as the FTC can, or as maybe some of the states can, that might be an avenue to think about how to consider censorship and speech controls in the context of these powerful platforms, even the ones that Twitter, I don't think anybody sees that as kind of like a traditional advertising monopoly.
I'm wondering, are you, if we are entering into these new territories, are you afraid of potential abuse of power by the agencies? I am, coming from Europe. For me, the question of independence of regulatory agencies is key. So, what do you see a problem here?
Well, I mean, now you could get me to be like mean to Europe. I don't want to do that. I think I'll just say I'm not convinced that independent agencies are any sort of panacea, or that independent agencies, like every FTC does whatever the president wants, and that's like always been the case. There's this idea that they like are oracles. They're all appointed by the president, confirmed by the Senate. They all have to get their funding every.
Best cases. I can't build capacity except you there. You see broad cases in the Bush administration didn't work. They would make. But anyway, go ahead. Occasional. I'm on occasion. I think Bill.
Don't point out I'm a hypocrite. I don't appreciate that at all. I mean, look, I'm afraid I don't want an authoritarian society. And I think you can look at that in a lot of contexts. I think that authoritarianism is coming from the public deciding that democracy is not worth it. Because like the legal community, the elites in DC are under attack. And I'm one of them, right? We're all under attack. I don't like it. I don't want to be under attack. I don't want to go bankrupt and whatever. But like, you got to remember, for 45 years, there are communities all over the country that have been destroyed. They've been, killed with opioids and deindustrialization, all these other things. And it's like, where was the solidarity then, right? People have decided in large swaths of the country, not everywhere, but large swaths of the country, they decided nobody cares about me, so I don't care about them. And it's like, that's a political problem. And I think you can read it through the lens of antitrust. I care about antitrust and consolidation because I think it's driving a lot of this stuff. But I don't think we can sort of see this moment and say it's obviously it's unusual, but there's definitely continuity here. And I don't necessarily think that there's no like seating charts. You can't seating chart your way out of this.
So I want to respond to Maciej's question about independence by referring to the world and what other agencies do, and a kind of notion in the world, at least among the enforcers, that independence is important. And it's not that they don't have a unitary executive. They're talking about something a little different. They're talking about an executive that interferes with what would be the normal and let's say proper, at least neutral enforcement by an enforcer who, for example, wants to sue a big joint venture or a big merger. That is, the online enforcer wants to sue something, a combination that is illegal, and the president reaches in and says, no, don't do it because that's my friend. It's that kind, and you don't have to talk about unitary executive or not. I mean, that's wrong, and it is a very big interference with the rule of law and the running of the system, and it should be called out, and usually there's not much more you can do in any society other than call it out.
So I'm not a lawyer, so I'm going to ask you guys. There's the other side of it. I 100% agree. The president saying, "I'll drop your this merger challenge if you do what I want." Totally corrupt, bad. But what about something like the law on TikTok, where it's not, there's no ambiguity there. It's just not like TikTok should be like banned at this point, and there's a bunch of companies that are running up liability. It's just because, the unitary executive, the take care clause implies you're supposed to take care that the laws are faithfully executed. Is there some sort of writ or something that someone can file? Because it seems really weird to have a unitary executive, but then he can just like not enforce laws if he wants to. And that's not a prosecutorial discretion issue, because it's not like it's a prosecutorial law. It's just, you can't be here if you're owned by. So is there a mechanism, a legal mechanism to say you have to enforce? Because we're seeing that sort of across the board.
Okay.
That's the other side of the coin, which is the failure to enforce laws.
So there have been a lot of articles written lately about what if our president does not abide by the law, by the court's order. This is a problem running into the same constitutional crisis that I started out with. There is a problem if the branches of government don't do what the law says you must do. And there's not an easy way to get it done, except recognize the norms that we have of following the law.
Okay. So I think it's time for questions, for Q&A. Please, there is a question.
More of a comment. I just think you should know that since you started this conversation, 4 more law firms have agreed to $500 million in pro bono work in agreement with the Trump administration for him to back down. Should I name them? Kirkland Nellis, Alan Overy's Chairman Sterling, Simpson Thatcher and Bartlett, and Latham Watkins. So does anyone have to leave the room now? I just think it's, there's no limiting factor on this, right? It seems like there's a snowball effect to it, whereby the law firms themselves, in some way, are perpetuating this by giving into it, right? I mean, anyway.
I mean, I think they should be disbarred. I think there should be mass disbarment attempts against these firms. I think it's absolutely outrageous. How can you call yourself an officer of the court? I think that's just outrageous.
On the law firms, I heard a really weird thing that these guys might be playing 10-dimensional chess because the orders themselves are not legal, which some of the firms have proved based on getting favorable rulings, and the actual agreements are non-binding. That whatever kind of Sharpie deal they're cutting with the administration, it's not enforceable because the original order is unenforceable, and they're just like playing along. And they're just assuming that he's going to lose interest, or time will run out, or something's going to change at midterms or whatever, that they're playing some kind of 10-dimensional chess and saying, let's pretend like we're placating our mom with dementia, and, and then they'll lose interest or forget about it or move on to something else, and we'll just go back to doing business as usual. Anybody have any thoughts on whether that's even plausible?
That's beyond what I know.
I mean, it's important to put out your question. I'm not done that.
I just think that understates the threat. I think it's real.
Okay.
Yeah.
2 questions in front. No.
Hi, I want to just bring this back to the media consolidation question. And you raised the Penguin case that I'm not that familiar with. But essentially, I want to bring this back to this issue about the diversity of ideas and whether or not media consolidation shrinks the field of ideas or whether or not it reduces output in some way. But basically, book publishing, as we all know, is under a lot of stress. It's a shrinking industry. It's extremely high risk industry. Something like 90% of what they publish never returns a profit. And only a few authors, maybe like Stephen King, actually help cross-subsidize the rest of their output. And so to me, when I look at a merger like that in a shrinking industry, what I'm seeing is a survival strategy. And so it seems completely rational to me that a court would say, well, yeah, we're not going to look at the quality of this output because I think, of course, they want to put out high quality stuff because they're defining quality as what people will buy. And so they're not in the business of trying to shrink the diversity of ideas. They're in the business of trying to find the ideas that somebody will eventually sell. So I'm just wondering if anybody wants to comment on that.
Well, I think first of all, I think one thing that might help, I guess it's to your point is there's been a huge concentration of the local journalism markets where now some substantial amount of towns and counties no longer have any local journalism corporations. And I think it's something that I've read somewhere like almost now like a majority of American counties only have one local outlet. And so I think that goes to your point but it also is partly like, are they giving what people want to buy? Where like, it's partly concentration, but it's also partly driven by less of a demand for product. But even if that is the case, it is lessening. Like it was in a lot of towns, there used to be, the more right wing and the more left wing newspaper that kind of spoke to each other, and things like that are just increasingly going away, where you do have a crosstalk of like a diversity of ideas.
But that's an advertising revenue issue, which is separate from the book publishing.
No, absolutely.
Okay, one more question from Richard.
Yeah, I got a question. It's a question from Matt, and it's kind of normative, and then it has to do with law. So there are no Chinese villains in American movies. Is that a good thing or a bad thing? Might there be national security implications? Information is always tightly controlled in warfare, times of tension. Was it better that we had James Bond Russian villains? Is there a normative position? And then I will say in Civil War, Second World War, information was pretty tightly controlled. And at least historians who look at that say that was probably a pretty good idea. So is it a peacetime, wartime? This is just outrageous because our media infrastructure has been so profoundly shaped by foreign. And then the implication is, should we extend this antitrust concern to election interference and other areas? Is there an antitrust dimension there? So it's a normative question, and it's a question about the law.
Right. So we need sort of more artisanal, localized censorship. No, that was just a joke that I had that I liked. Yeah, it's all right. All right. So I think that when I said there's no Chinese villains in movies, I think that it's true, but it also is. It's more like it's a bad thing. Okay, it's just a bad thing that the only things you can say about the Chinese state are, yay, right? Look at how awesome their space program is. But more like the bigger problem is, you go to Hollywood, talk to people who work in the industry, and they'll just say, yeah, I have a documentary on this thing that involves China. I can't get distribution, which is not about whether you're demonizing people. It's just like, if you want to say something about China, which is important, it's an important factor in a lot of what we do, you can't. That's kind of what I was pointing at, and I think that's bad. I don't think that we should be demonizing China or putting lots of Chinese villains in, but I do think that we should be able to do that if you're writing a story and, the Chinese government is peripherally involved. Like there's a lot, there's a lot there that you can talk about. I don't think you should be excluded from doing that, and we are, and I think that's kind of what I was pointing to. Now you're saying, does that election interference? Well, I mean, so is that a response to the Ken Klippenstein story, or is that just trying to get a sense of your question?
Is there a legal antitrust convention. If we have a free marketplace of ideas that are not important consumers.
So yeah, I think so. One of the things Tim Wu has said that got him a lot of flack, he's not there now, but he said that we overinterpret the First Amendment, and I think that's right. It's this boundless thing that doesn't stop anywhere. I think this idea of an open and free world, the free flow of information, is crazy, and totally ahistorical. I'm with you on that, and I do think there's a role for the state to guard and bound the information flow, because if the state doesn't, then China's going to do it, or other states. There's no world in which there isn't power, right? There's just what is the right bargain to figure out how we bind ourselves together as a society. And to that end, I think that the way that we have to get back to some of the earlier principles of really decentralizing power over the information commons. So I think some of the same things that protect us from coercive behavior of domestic elites, aka small business, diversified financing streams, lack of consolidation, neutral public utility style rules, also protect us from foreign interference. I do think we probably need extra rules on foreign interference. Citizens United has an exception carved out for foreign speech. So I'm very much with you there, and I think we need to start to cabin this crazy First Amendment arguments, which have gone nuts.
And point out that those restrictions or concerns of foreign interference absolutely set those upon it, and they completely ignore it.
And they're actually a global problem. I mean, you see the thinning out of local news everywhere in the world, and that is a huge geopolitical problem for the United States and for people who think that democracy is important, because China is taking advantage of that to become dominant in spreading their arguments that liberalism and democracy is a bad system, right? And that you need a different order. Now, whether maybe you think that's good, but it certainly is if you pull the capital out of media, which is what's effectively happening, it's being redirected from media to this Palo Alto or wherever. Then what you're doing is you're thinning out the conversation worldwide. And I think we don't talk about the effects of these, the discussions about disinformation abroad, but what about the effects of pulling capital out of local news everywhere in the world? That's a big problem.
Okay. Thank you very much. Thank you for this panel.